Okay, Committee Chair. Committee Chair Scholes.
Present.
Member Betancourt.
Here.
Member Duesel.
Present.
Member Johnson. Executive Director Robert Reposa.
Present.
Legal Counsel Graham Carshall.
Thank you.
Okay.
Thank you very much. Well, it being 1:47, when quorum is hereby declared, we'll open a meeting of the subcommittee. There are two items on today's agenda. Item number one, the Legislative Committee will discuss and vote to approve the minutes of the meeting held on Tuesday, March 17, 2023. Have a motion?
I'll move to approve the minutes as presented by the clerk.
Second.
Okay, all in favor? Say aye. Aye.
Aye.
Opposed? No? The ayes have it. And the second item on the agenda is the Legislative Committee will discuss and vote to suspend the Legislative Committee for 2023, subject to the call of the chair.
I'll make that motion.
Do you have a second?
Second.
All in favor, say aye.
Aye.
Those opposed, say no. The ayes have it. That completes the business of the subcommittee. We'll entertain a motion to adjourn.
So moved.
Okay, all in favor, say aye. Opposed, say no. So moved. Committee is adjourned.
Rhode Island Board of Elections is now in order. It is 2:00. Madam Secretary, will you read the roll?
Thank you, Madam Chair. Chairwoman Maderas,
Here.
Vice Chairman Pierce, Member Bettenker,
Here.
Member DeSimone,
Present.
Member Johnson, Member Scholes,
Present.
Member West,
Present.
Executive Director Robert Raposa,
Present.
Legal Counsel Ray McCarthy. Thank you, Madam Chair.
Thank you, Madam Secretary. First item on today's agenda, the board may discuss and vote to approve the minutes of the meeting held on Tuesday, March 7th, 2023. We have a motion by Mr. Scholes. Do we have a second?
Second.
Seconded by Mr. DeSimone. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed, unanimous vote to approve. Item number 2, the board may discuss and vote to approve the minutes of the meeting held on Tuesday, March 21st, 2023. Do we have a motion? Moved by Mr. Scholes,
Second.
seconded by Ms. Bettenker. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed, unanimous vote to approve the minutes. Item number 3, Executive Director Robert Raposa will present a report on the anticipated special election schedule for the Congressional District 1 primary and election to be held later this year due to the announced resignation of Congressman David Cicilline. Mr. Raposa.
Good afternoon, Chair and members of the board. Since the announcement by Congressman David Cicilline on February 21st that he would resign his congressional seat in Congressional District 1 effective June 1st, the staff immediately began working with Governor McKee's legal division and the elections division of the Secretary of State to develop potential election calendars while also seeking input from the Board of Canvassers in Congressional District 1. We attended several meetings with the governor's legal staff, we being the staff of the Board of Elections and Attorney Macaccio, to provide input on the writ of election the governor is authorized to issue under 17-4-8, as well as to ensure that proposed legislation by this board worked in tandem with the writ. Your proposed legislation is Senate Bill 840, sponsored by Senator Frank Lombardi, and the House Bill is 6185, sponsored by Representative Evan Shanley. Both of these bills are scheduled for hearings this week. The staff of the Board of Elections will be present at those hearings. On March 29th, Governor McKee published the dates for the special primary and special election to fill the vacancy in the United States House of Representatives for Rhode Island's 1st Congressional District. The election will be held on Tuesday, November 7th, with the primary being held on Tuesday, September 5th. These dates are contingent upon the resignation of Congressman Cicilline taking effect on June 1st. Declarations of candidacy for the seat would occur on June 29th and June 30th, with candidates being required to submit their required 500 signatures to local boards by July 14th. This board would be required to decide on any objections to nomination papers by July 21st. Following the release of the potential dates, the governor's office invited the 19 local boards in Congressional District 1 to join representatives from the governor's office, the Secretary of State's office, and the Board of Elections to answer any questions related to the special election writ on a Zoom call March 30th. Chairwoman Maderas and Attorney Ray Macaccio participated in that Zoom call along with members of the Board of Elections staff. These dates are tentative, again, as of this meeting, as the governor will finalize these dates when he releases the official writ at the end of May. During the call, some local boards expressed concerns about schools being unavailable during both the special primary and the special election. 93 of the 195 precincts in Congressional District 1 are located in schools. This presents a serious challenge to local boards who must work with their school districts to request these dates be used as professional development days for teachers during which time classes would not be in session, and it's more feasible to use the facility as a polling place. While there is currently no restriction on a school as a polling place while schools are in session, in recent years, this has been done much less frequently given the security concerns in our schools. In addition to problems with parking, traffic, and access to rooms that are usually in use by the students, such as cafeteria or gymnasiums. Polling places must be selected for the primary by July 17th. We will continue to work with the Board of Canvassers to determine if they can request local school departments in Congressional 1 to modify their calendars to accommodate the special election. However, this may be challenging because some districts have already set their calendars. Under current Rhode Island election laws, local boards are allowed to request the combination of precincts in special elections under state statute 17-11-1.1. However, the combined precinct cannot exceed 3,500 voters. The City and Town Clerks Association has submitted proposed legislation to the General Assembly, which is Senate Bill S0613 and House Bill H6240, which would allow combined polling places to exceed the current 3,500 voter limit with the approval of this board. This board voted on March 7th to support this legislation. Passage of this legislation is crucial as it would allow local boards to combine precincts currently located in schools into other locations. As you know, during special primaries and elections, election day turnout is generally much lower than statewide primaries and general elections, particularly with an increasing number of voters choosing to vote by mail or during the 20-day early voting period. The result is that combined precincts are clearly able to be assigned more voters as a much smaller percentage of voters actually use the designated polling location on election day. We will work with the City and Town Clerks Association and the local boards to support these two pieces of legislation, which are critical to the successful conduct of the congressional district, special primary, and special election. Yesterday, the election staff and I held a Zoom meeting with the canvassers from Congressional District 1 to discuss potential alternate polling places if they are required to use them if it is determined schools are unavailable. This concludes my presentation and update on the upcoming special Congressional District 1 primary and election to be held in the coming months.
Thank you, Bob. Any of our board members have any questions or comments they'd like to make at this point? I think you explained it very well and thoroughly. Appreciate that. I think we'll go on to the next item. Thank you, Bob.
You're welcome.
Item number 4, the board may discuss and vote upon the submission of a sub-A in order to modify legislative bill H6032 pending before the General Assembly in accordance with the language attached to this agenda. Mr. Reposa.
Regarding the sub-A for House Bill 6032, regarding mail ballots and voters unable to sign their name on either the application or the ballot certification envelope. This bill is being sponsored by Representative Evan Shanley on behalf of the Board of Elections. At your board meeting on February 7th, this bill was presented to you by the staff in its initial draft. However, advocacy groups had provided feedback suggesting that the term physical incapacity or otherwise be replaced with language used in Rhode Island General Law 17-19-26.1, which governs providing assistance at the polls. In that statute, a voter may receive assistance from someone due to blindness, disability, or being unable to read and write. The staff and the board members agreed with the suggestion, but unfortunately, the change was never voted upon and never made it into the final motion or the version that was submitted for submission. The new language, which was language you discussed at your February 7th meeting, has been incorporated into the sub-A presented before you today. During the House committee meeting, it was discussed at that time that this should be put back into create a sub-A, including this language, and that is why it's back before you today, because this was a bill you submitted to be sponsored. At this time, if there are any questions, I will turn this portion over to legal counsel Ray Macaccio to explain why that new language was added as part of this proposal.
And as I recall, Bob, the board was generally in agreement with this change when we had the meeting, but I think it was just an oversight that we never actually voted to make the change. So yes,
I agree.
I think you're right. Yes,
Can I
Mr.
ask a
Macaccio?
clarifying
Yes,
question
of
before?
course.
So you mentioned that it's been heard in the House, so it has not been heard in the Senate yet.
That's when it comes back to me. But yes. So it is being heard today in the Senate. I expect that after the Senate hearing, it will then either be, when it's submitted, it will either, the House bill that you approve it today will find its way to the Senate, or the Senate bill will come back to us and it will go back before you at a future meeting.
Mr. Macaccio? anything to
Thank you,
add?
Madam Chair. So as Bob mentioned, one of the purposes for the change to Chapter 20 was to make it uniform with Chapter 19 and further clarify what it means for someone who is unable to, at that point, make a signature and instead use an X. So we have added that language for that purpose. There was also a discussion, I was part of it, with what other assistance you may be able to provide to the voter who is actually unable to make his or her own mark. So if you have somebody who is incapacitated and unable to physically hold the writing instrument, what else could we do, if anything? So before you, that's for our discussion as well, which would be to allow the assistant, a person chosen by the voter, to assist with the making out of the application, and in those cases where the voter cannot physically hold the instrument, then that assistant could affix the signature for the voter. Now, if that were done, if any time you don't put your signature down, so you're either using a mark or you're having somebody assist you with the signature, we would also have to add a provision that the necessity for using that option satisfies our statute, and that will be attested under pains and penalties of perjury. So we've lost certain security measures with respect to that whole process when we went over to removing the witnesses and the notary. So in this very narrow group of voters who actually cannot put their signature in, what can we do? And that would be a possibility. I think that's open for your discussion and your vote today. But so throughout these revisions, you'll see that we did add references to the person, the representative, assisting with that process. And that culminates at the very end. But if you even look at 1722.1, as well as 1723 under definitions, that person could provide assistance to the voter in accordance with these requirements. 1728 would allow for someone who is unable to affix their signature to do so. And then under 172021 on the certification of the envelope, and 172013, you'll see the actual forms here. And these would be the language that would possibly be used to provide some protection when you have someone else affixing a signature on behalf of the voter. I think, obviously, there are concerns anytime you have someone else involved at that level. That's why we wanted to at least talk to you about this as a possible option. But really, the purpose, the intention, I should say, is to make sure that those who really are unable to physically mark the ballot have the opportunity from an assistant to do so.
Okay,
Madam
any questions? Yes, Mr. West.
I have one. At the end of paragraph B, 7/20/21, 2.1, it shall be made under the pains of and penalties of perjury. What are the penalties? Do we have any penalties?
We have penalties and also the Attorney General. When you talk about perjury, you are talking about a criminal matter. So this would be referred over to the Attorney General for prosecution. My recollection is that in years past, some of these prosecutions have been for a misdemeanor, others have been for a felony. Now, I suppose the thing you could consider doing is a notary provision, but I tended away from that because we've already decided that for all other voters, we're not going to use that mechanism. So it seems to me that one could argue that for that segment of the population who is in most need of assistance would suddenly be the only one who has the burden of getting a notary. So that brought me back to the idea of just a signature attesting that I cannot sign this. And the assistant, the person providing assistance, that is him. I'm signing on his behalf. I'm affixing his signature, and I do so with that pains and penalty provision.
Okay,
But the penalty will be decided by the court. Is that right?
Right. So every case is different. So I suppose that if you had a situation where it was willful, may have been a number of people involved, I suspect that the Attorney General would look at that and go for the strongest penalty possible. We always have to be mindful that there's prosecutorial discretion, and that our job is to refer it out, and theirs is to exercise that discretion and prosecute accordingly.
Mr. Schultz, you had a question?
Thank you.
Yes, we have. Randy, you indicated that as a person provides assistance to the voter, does that person have to be a voter in this state to provide assistance?
There's nothing in this version that requires that. So if you went to a voting booth and you were at the voting place and needed assistance, you would have the designated officials from that polling place assisting you. This version does not require you to be a voter.
Well, I'm thinking about the mail ballot goes to someone's home. The person who provides assistance doesn't even have to be a citizen of this state. Under this provision, that would be a proper reading of that?
There's no requirement for citizenship. There's no requirement for being a voter. That's correct.
Or would there be a requirement for age? In other words, can a person who's underage sign?
Okay, that one, if that's not clear, that one I can't answer offhand. I believe that person is defined earlier, but it would, I think, include only adults. But if it didn't, that would be a modification that would be necessary.
Because I think if the person is a voter in this state and is providing assistance, we can always double check that signature of that person against the voter base to know that that's the person who actually helped. If a person's not in the voter base, we have a bit of a problem.
Mhm.
That's a concern.
There is an attempt to address that concern by making sure the address is also included.
Right.
But those are very good points.
The other thing is says on a form provided by the Secretary of State.
Mhm.
Is that a form other than that was on the certification envelope? In other words, is there additional form that has to be filled out?
Bob and I have not discussed that, but it would have to be the form that we're referring to at the very end of these modifications. So we have the application form, which is actually part of our statute.
So that would be printed on every form that's submitted to somebody who's voting by mail.
It would be part of the application, yes.
Because of the
Every
person,
person would have that because they, at the time that they made the app, well, they may have circumstances arise
Yeah.
that necessitate that even during the process.
because I think it would be sort of a burden on someone who doesn't have that on that form, now try to find the additional form to allow that
Correct.
person to assist to fill out that form. So I think it
Yeah.
all has to be included.
And chapter 20, which does include the forms, are being modified. If you look at the very end, the last 2 or 3 pages of that document, you'll see those changes as well, including the oath of the voter as well as the assistant.
Well, like I said, my only concern here is that the person who assists should be a voter in this state. Other than that, it looks good.
Any other comments or questions?
I have a question.
Mr. DeSimone?
So, Ray, is it 17/2013 where you're talking about the form of the application as part of the statute? That's like the last 2 pages.
It's at the very end, yes. Yes.
So if we go to the end of it, that's the oath of a voter, correct?
That is the oath of the voter.
So I guess my question is the party providing the assistance going to be required to make an attestation?
Whoever is affixing the signature was the intention. So if there was somebody who is signing on behalf of the voter, that person will be making the attestation.
But let's say the voter's making a mark.
Well, that would be different. Then it would just be the voter. But if the voter can make the mark, then they likewise would be making the attestation.
So
It would just be for that
in
very,
this particular case, let's call him the assistant. Okay. So if the assistant is signing for the voter, then as I read this, the assistant is casting an oath for the voter, not for themselves.
that's right. That would be in conjunction with the voter saying that that person is physically incapable and therefore I'm a proxy for him.
I mean, for me, I think there needs to be more done on this to have the person who's assisting take some responsibility. I've got particular concerns as Commissioner Scholes with regard to the mail ballots in particular. I'm concerned with the potential for abusing mail ballots with this legislation as it sits. And again, it may be my age, but I come from a time when mail ballots were an industry in and of themselves. And I would be concerned with the fact that there's no attestation by the person casting this. I'd also like to see, frankly, it made a felony and specified a felony in the statute, frankly, for the party casting the ballot if they do so either fraudulently or without the voter's consent. My real concern is preserving the voter's vote rather than have someone else cast a vote for them. So I just think there needs to be more burden put on the person casting the vote for the voter, or filing the application for the voter as well. So that would be my concern with regard to the draft as it sits. But that's just.
Any other comments? So does the board wish to take an action, perhaps referring it back to the staff?
Yes, I move that we refer back to the staff to meet the concerns that were raised in this meeting.
Do we have a second to Mr. Scholl's motion?
I'll second it.
Seconded by Mr. DeSimone. Any discussion?
I have a question comment.
Yes.
So does that mean that some of the comments that were made about the person's residency, like, are those just going to be added or I'm not entirely sure what some of the comments, how they'll be.
Well, there were a
amended.
number of comments, so I think
Correct.
that what has to be done now is that the staff has to discuss them and see what makes sense, and then
Bring it back to you.
bring something back to us that we can look at, and if it
Mhm.
meets the, the concerns of the board members, then we can vote on it.
Interesting.
Is there a consensus that you want to have the signatory a voter? My only concern is if we come back for another vote and it goes up for a vote and the majority say no, it could just be something else. Is it clear the board would like to have the language that Mr. Scholes suggested?
If I can say, I
Sure.
don't think that the residency should be a thing. If I live in Massachusetts and I need to help my mom, why wouldn't I be able to help her? I think there are aids, and I think that is an issue that would be running into if you're saying that we can't, if they have to be a
Well,
voter of the state.
it's more than that. It's also a segment of these will by their very nature be out of state.
Mhm.
So I don't know if you're using the mail ballot because you're in Wisconsin temporarily and you have a physical
That's right.
incapacity. It seems to me that the ability to get a Rhode Island voter would be possible,
Impossible, probably.
could be difficult.
But if they sign in the state of Rhode Island, that would not be an impossibility.
Right. So you would split it down between those who are in the state and not.
Those who are in state, that way we can compare the signature of the person who assisted against a voter base.
So would that be a different layer into the legislation, like dividing this is signed either inside or outside?
Yeah, even if the voter, even if they sign outside the state, there should be at least a registered voter in that state. But you're asking this person to be the proxy for the voter. So how do we control, determine who that person is? We need some sort of measure to locate that person. If a dispute arises.
My feeling is that there should at least be a name and an address
Correct.
somewhere in that document.
Well, that we have.
Because I think that way, to your point, we can find who these individuals are. Nevertheless, they might be the aid to a person in several different ways. And I think sort of making this very specific, like hard decision of they have to be a Rhode Island voter can be a detriment and a huge barrier for a lot of people. There's people who have aides who may not be U.S. citizens, but are the trusted aid of this individual.
That's a good point. Do
That's
you have any
very
thoughts on
true.
this, Mr. West?
Yeah, we have to go back to before we changed the process of signatures and had witnesses, and you had people that were out of state in college or what have you,
Yes.
and people signed as a witness, and these were people who didn't live in Rhode Island. They lived somewhere else, but we accepted those signed on the ballot that there was witnessed by whoever put their name there,
Correct.
and they were out of state people.
That's a good point.
So, that's how are you going to require that after you, and we accepted those before.
Right, understood. Mr. DeSimone, did you have something you want to add?
No, I'm not as concerned as with the citizenship of the party or the voting ability of the party. I think it should be someone over 21, frankly, or at least someone over 18. But I'm more concerned with the fact that both on the application and on the ballot itself, we're discussing that the representations are going to be made under the penalties of perjury.
Mhm.
And quite frankly, if someone in Wisconsin executes a document, I'm not as concerned because it's one document. I'm more concerned with the gatherers of mail ballots. Those people in the state that gather hundreds and 200s of mail ballots at a time. To simply say that we're gonna execute something with a signature, which you may not even be able to read, indicating that these 20 people said they were going to make their mark on here and were incapacitated. I'm frankly concerned with the situation where someone is divested of a vote because of that.
So I guess the question is, how do
process.
we remedy this? I mean, if you're
And
looking for.
I don't know the simple
Yeah.
answer to that. But that's my real concern. I don't have as much a concern because certainly, someone from out of state helping a mom or an aunt or a cousin or a grandparent, I mean, I don't know that you're going to be able to require that they be a Rhode Island voter. I think that's going to be an impossibility.
Maybe I can help this way. I can tell you that this is just a kind of like a microcosm of the discussions that have occurred amongst the staff over
Sure.
a period of weeks, because there's no easy answer.
Right.
Possibly what you could do is remove the option that the voter can use someone else to sign the application and just leave it to the voter to affix their mark as it was originally introduced. Now, we used to have X, we've made that now whatever your mark is. That would at least advance us towards providing additional rights to those who have a incapacity. Up until this point, the law has always required you to put your own mark, your own X, and perhaps you just keep it like that, do it in grades, and we may never go any further, but at least see if with these other modifications, removing the reference to the assistant affixing the signature of the voter, leave the remainder of it that way so that the assistant can assist with, filling out the ballot, the application, for example, but not affix a signature. That would be only for the voter with a signature or their mark, and leave it at that.
So would this require a sub A then?
I think it would, because we are adding other things in there with respect to the address and the things with the assistant. But we could just modify it. The board could take a vote saying all accepted with the exception of allowing the assistant to sign on behalf of the voter. That's one thing that might allay some concerns. It may not allay all of them. I don't know.
What is the thoughts?
Well,
Yes.
that's what was the discussion of here, sort of prompted me to think about, I think the main thing is, what is the relationship of the assistant to the voter? And I looked at your application, and it doesn't include what the relationship is.
I don't think it,
Should, at least the relationship, the mobile phone number, and email, contact information. So at least we'll know who that person is, whether it be an aide, or a relative, or a friend, or a neighbor, we'll know what the relationship is. And the person is acting as the proxy for the voter.
I think that we do request the address of the person who's providing assistance.
We do.
Right, the street address, no email,
There's no,
no mobile phone number.
yeah,
Okay, we have that on an application for a mail ballot, the person's applying for it, but this person who's actually voting on behalf of, the elector, we should have some control on it.
yeah. Is that now part of the application, the email address?
It is not for the assistant.
Yeah,
Um,
but I meant as far as the voter, they at this point are now providing the email address.
They can, it's not required, it's optional.
Well, and I think what Mr. DeSimone said, at the very least, there should be a printed
A
name
field,
and then
a
a
field for it.
signature, because it's always impossible to read signatures. But what were you going to say, Mr.
If I
Raposa?
could provide a suggestion, I would suggest that the board take a motion and to have the staff along with the attorney, revisit this and bring it back to you at the next board meeting, which is May 2nd. And because we would dig into the changes that need to be made and also work with the elections division at the Secretary of State's office. Because if we are going to start doing more with this application in the oath envelope, that is their responsibility for producing. And I know that they would like one universal application and one
Absolutely.
universal oath envelope.
Makes sense, doesn't it? Okay, does the board wish to take an action?
I think we have a motion on the floor right now.
We did.
Yeah, refer to the staff Yes,
I thought we actually had that conversation. Who made the motion?
I did.
You did. That's why you remember it so well. And who made the second?
I think I just,
Mr. Di Simone. Okay,
and then I
so
think the question and discussion was, what specifically are we directing the staff to?
exactly right. So we're back to that. Okay. Now I recall. Okay, so we have a motion and a second to refer this back to the staff, and you're to
We'll
come
bring it
back to us.
you.
And the timeline allows for that at this point, would you say?
Hopefully, yes.
Okay.
If I hear otherwise, and we will work to get a revision, we would have another board meeting between now and
We
May
did have another
2nd.
meeting. Okay, so we'll leave that to you
Okay,
to pursue.
yes.
Okay, we have a motion. All in favor, signify by saying aye.
Aye.
Opposed? Unanimous vote of the board. Item number 5. The board may discuss and vote on the appeal of campaign finance fines by Scott W. Fuller pursuant to Chapter 25 of Title 17 of the General Laws. Mr. Thornton, we'd like to hear from you.
Is Mr. Fuller present, Madam Chair?
Mr. Fuller present.
Would we ask him to come up as well?
Is he here? Okay. Yes, please do.
Good
Did you-
afternoon, honorable board members. Scott Fuller ran for State Representative District 67 in the 2022 election. For some background, on January 20th, 2023, he submitted copies of his campaign bank account statements for October, November, and December 2022 and January 2023. All candidates are required to submit a copy of their year-end bank statement. We compare the bank statement balance with the campaign finance report balance as of the end of the year. Any kind of discrepancies, we ask for reconciliation. We assist candidates in reconciling their campaign accounts if there is a variance. Campaign finance representative Lisa Birchfield, who's at the table as well, compared the information contained on the bank statements to the information on Mr. Fuller's campaign finance reports for the period October through January, and noted a small variance at the end of the year, but multiple discrepancies between information contained in the bank statements and information contained within the campaign finance report. As a result, ESA requested and received from Mr. Fuller additional campaign bank statements and supporting documentation dating back to April 2022 through September 2022. So essentially the entire campaign period. This was done to assist Mr. Fuller with the reconciliation of his account. During that review, there were findings of discrepancies. I'll go through those briefly. There were a total of 17 in-kind contributions from Mr. Fuller personally, totaling $672.20 that were either not reported on any campaign finance report or reported incorrectly as campaign expenditures on a campaign finance report. There were a total of 4 contributions and 32 expenditures not reported on any campaign finance report. WinRed, which is a third-party contribution portal, transactions were not accurately reported on some campaign finance reports. There was a cash withdrawal of $50 with no receipt of documentation to validate it as a campaign expense. A contribution of $150 was reported on a campaign finance report as received from an individual when in fact it was received from a business, which is prohibited. There were 2 contributions which were missing home addresses of the contributors. And since anonymous contributions are prohibited, the addresses were required. ESA worked with Mr. Fuller. The deficiencies were all corrected satisfactorily. But in the process, 2 of the campaign finance reports were materially amended. Back in April of 2010, a regulation was passed which defined a materially amended campaign finance report, which means it shall mean to add, delete, or alter more than $500 or 10%, whichever is larger, of the total fiscal sum, either of the contributions or expenditures on any campaign finance report. When a filer submits a campaign finance report to the Board of Elections that is not substantially complete and later materially amends it, the date of the amendment will become the actual filing date. As a result, late filing fines and fees may be assessed pursuant to Rhode Island General Law 17-25-11G. As a result of the two materially amended campaign finance reports, Mr. Fuller was apprised that late filing fines totaling $50, which is $25 for each of the two reports, were assessed to him. I omitted to add the $2 per day fee for each report. Had the $2 per day fee been added, again, using as a comparison, the two reports were the second quarter report and the 28-day before election reports. Had the $2 per day fees been added, the second quarter report's fine would have been $347. The 28-day before election report would have been $207 for a total of $554. I administratively waived the fees and assessed just the base $25 per report. On February 13, 2023, Mr. Fuller appealed or asked if he could have a waiver of the $50 fine citing income. On February 17, I apprised Mr. Fuller that his appeal for a waiver was denied as the daily fees had been excluded from the fines that were assessed. Also on that same day, Mr. Fuller requested to appeal for a waiver of the $50 before the board.
Any questions of Mr. Thornton? Mr. Mercatio, do you have anything to add?
Not to add, I have a question for Mr. Thornton, if I may. When you say that there was a contribution you discovered from a corporation, how did you make that discovery?
The source documentation we received with the bank statements showed the copy of the check.
The check was from a company?
Correct.
And who cashed it?
It was deposited into the campaign account. Again, that was cured. The money was refunded back to the business owner, and subsequently, I believe, was turned around as a personal check.
Is that it, Mr. Mercatio?
Yes.
Should we swear in Mr. Fuller?
If we're going to get any testimony with respect to his claim of income being the basis, we would need an explanation as to why he's unable to afford it.
So we should swear.
He should be sworn in.
Would you raise your right hand, please? Do you solemnly swear that,
Can I ask you a question first?
You put your hand down if you're going to ask a question because you're
Yes.
being sworn in.
I haven't done this before.
Go right ahead.
It's for income, but it's also one of those things where I just don't agree with the rules. So it's-
We're unfortunately, for a number of reasons, we're stuck with what you filed. You filed saying one word, income, and then followed up, I believe, Mr.
okay,
Thornton.
so we need to swear in the gentleman. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Tell us your name and your address.
Scott, for which one? It's not even working.
Looks like it's on.
Scott Fuller, 23 Belvedere, Barrington,
Okay. Would you-
Belvedere Avenue, Barrington, Rhode Island.
Madam Chair, before he starts, I just have one question.
Sure, go ahead.
So, Mr. Fuller, do you agree with the summation that was provided that those mistakes were in fact made?
Absolutely, I
Okay.
do.
Thank you.
Yes, I appreciate I do, absolutely. Do
Okay.
not disagree with any of that.
Thank you.
I do not. And I appreciate the waiver of the fees that Mr. Thornton told me about last Thursday. I
And
do.
can you share with the board the basis for your statement to the board that you don't have the income to pay the $50?
I will at some point. Can I just give some background about who I am and?
Can you
some
start
other-
with that first? Because I've asked it, and unless the chair does not want me to,
No,
go
no,
in
that's
that
a-
order.
that's the pertinent
You-
question.
I just want to know the basis for the appeal that you can't afford the income of $50.
Well, I'm a retiree of 4 years. I'm on fixed income. I have expenses. And
That's the basis?
it is.
Okay. Do you own your own house?
Do,
Do you have a mortgage on it?
don't,
Do you have fixed income in the form of a pension?
I do.
And is the pension from a municipality or state?
It is.
Which one?
Rhode Island.
And what is the pension payment that you receive on a monthly basis?
In the amount?
Yeah.
My wife does the books. It's about 3,000-ish.
Okay,
I don't know the pennies with the
okay.
ish.
Did you file anything other than the email to Mr. Thornton in support of your appeal? There was an email from him on or about the 13th saying the word income. Is that the only thing you filed for your own appeal?
I believe so. I don't think I filed anything else.
Do you have anything to add?
Can I tell you a little bit about my background and some information that pertains to
Sure.
how I'm here?
We'll give you a few minutes, sure.
Thank you. I'm not looking to take more than 5 or 10 minutes, to be honest with you. I know it's not a first world problem. I'm just turned 69. I ran for school committee in 2010 successfully. I was not successful this time around. I'm a retired parochial school principal, vice principal, and math teacher of public high school. Happy grandfather of 6 kids, married to my wife for 46 years. I undertook running this back about last March or April, knowing that it was going to be an uphill battle for a Republican to win much in this state. That said, went through the process, lost, and wouldn't have traded it for the world. Why am I here? I'm here, yes, for the $50, but at the same time, there's some things that going through the process I have concerns about.
You should file that, Mr. Fuller, with the board as an appeal if you think you have merit to do so. I have not seen that, nor am I advising my chair and my board to listen to that when you haven't even had the courtesy of filing the basis for it.
I can't read emails from the Board of Elections to my.
Put
back
it
and
in
forth.
appeal, sir. If you think you have an appeal, you can file an appeal. I've
I-
seen your appeal. It is, in my view, frivolous, and at the very least, doesn't even comport with the regulations that require you to file something in writing to this board.
Okay, the chair said I could speak to my circumstances. May I do that now?
We need to hear from our attorney as well, sir. And if he's advising us that we need something more material, then perhaps we do.
What I'm saying, Mr. Fuller, is you should file an appeal if you think you have a basis. The basis was one, income. If you have other reasons, the board has every right to hear what they are in writing, as does the staff, so we can understand the basis. You are entitled to due process, but you have to follow the rules. You haven't so far. It's amazing, or even here, sitting in this at this time.
Okay.
But-
Well, let me ask you this. Can I read some emails, some correspondence and my experience with this relative to the appeal or not?
That is entirely up to the board.
Does that comprise a basis?
I mean, that's up to the board members. I have no problem hearing it, so
Do we want to hear from the gentleman? And
It's 5 minutes. It's not going to be forever. I don't expect to be here. I have a wife to feed and 2 rescue dogs to be walked. I appreciate the time.
we'll give you a few minutes. Go ahead.
Thank you. I have 3 concerns, and I'm hoping that 2 of them might be able to be addressed by Mr. Thornton of the board. The first concern, I'm glad Ms. Birchfield is here. I did have a concern when I met with her privately. She asked me to bring paper receipts for the 6 months because they had concerns about some of these discrepancies. I share those concerns. I did not do a good job. I ran in 2010, and the guidelines were very different. You didn't have to have a bank campaign account, didn't have to take a credit card, didn't have to take pictures of checks. I found this all about months after I did this. Small concern with Ms. Birchfield, but it is what it is. During the conversation, when we had chatted about some of the mistakes that she mentioned, she told me I was being very rude when I was asking questions. She also told me at some point, I should have.
excuse me,
This
Madam
isn't,
Chair.
this isn't pertinent.
That I'm not going to listen to.
Yeah.
Okay.
So I'm going to make a motion if that continues. But
Yeah, we
I-
need
I-
to stick to your.
I don't want to hear that employees are being disparaged in some way. This isn't that kind of a
She's
hearing.
right here to defend herself.
Unless my legal counsel tells me I have to hear that,
She's
I
right here to
don't
defend
see
herself.
how that's material
That's
to an
not why
appeal.
we're here,
Right,
sir.
right. She's right here to defend herself, for Pete's sake. Okay,
We-
I'll
we
move
are-
on. I'll
Move on.
move on.
Move
Madam
on.
Chair, I have a motion. I would
Madam Chair.
move to deny the appeal. And I'd move to authorize Mr. Thornton and the department to not only collect the $50 fee, but in their discretion, add the $2 a day.
We have a motion by Mr. DeSimone. Do we have a second to the motion?
Second.
Seconded by Mr. Scholes. Any discussion? No discussion. Hearing none, all in favor signify by saying aye.
Aye.
Those opposed? It's unanimous.
Can I continue to read the other part of my
I
concern?
think we're finished, sir.
You've got to be kidding me. This is a taxpayer and this is what I get before this group? Are
Sir, you,
kidding me?
you should have filed an appeal that was
I was
in,
never told I could file an
yeah.
appeal.
Well, let me just say one thing, Mr. Fuller. You said you knew very well what was in place for 2010. It seems very clear you did not take the time to see what was in place for 2022. That is not Mr. Thornton or Ms. Birchfield's fault, despite your comments to the contrary. You've got to follow the rules.
Is there anything else I can say?
Matters closed on the agenda.
Well, I'm not about to find. Can I just share some concerns I have? Forget the personnel thing?
File it. File it so that the
File it.
board has an opportunity to hear exactly what the basis is.
Well, it's just concern with,
50 bucks.
I was given an email by Mr. Thornton who said I owed $300, $400, $350 was for two, no addresses, okay? And then one was for the check that came out of the corporate account. I understood. He said, these are forfeitures. This is money that you owe. I said, wow. I said, I wonder if I can fix these.
Oh, I think we.
Mr.
cleared
Fuller,
this up
we've
here. I think,
we've
uh,
heard your
you have
concerns.
to file a
I
complaint.
didn't even get to finish, for Pete's sake.
I know that. Thank you.
Is that fair to tell me I owe that money and not even know that I could appeal?
Sir, this item is concluded. Thank you.
This is disgusting.
Item number 6. The board may receive a report from Richard Thornton, Director of Campaign Finance, concerning 2022 matching public funds. Mr. Thornton.
Thank you. All right. 2022 was an election year in which the general office candidates could apply for public funding of their campaigns. There were 15 general office candidates that filed their intent to receive matching public funds, broken down into 4 candidates for governor, 4 for lieutenant governor, 2 for attorney general, 2 for general treasurer, and 3 for secretary of state. To receive matching public funds, the candidate needs to qualify for placement on the November ballot. So if it's a party candidate, they have to be the nominee of the party. Unaffiliated candidates can also receive public funding, but there are other eligibility criteria they must meet. As far as those qualifications, anyone to receive public funding would also need to receive, for governor, $259,600 in private donations, and for the other general officers, $64,850 in private donations. The candidate for governor would also, of those $259,600, there must be a minimum of 250 individuals contributing at least $25. For the other general office, 100 individuals contributing at least $25. So of the 15 that applied for matching public funds, there were 5, 1 for each general office that actually did receive public funding. And that would be Governor Daniel McKee, Lieutenant Governor candidate Aaron Gukian, Attorney General Peter Nerona, General Treasurer James Diosa, and Secretary of State Greg Amari. The maximum amount that the candidates can receive in public funding for governor, it was $1,298,000. For the other general officers, it was $324,250. The amount is set by the change in the consumer price index between the election cycle when the general officers were last elected. So between 2018 and 2022, the amount of public funding available to each candidate increased by 10.28%. Once the primary has been certified, the candidates will submit their paperwork to the Campaign Finance Division, consisting of copies of checks they've received for contributions, contributions they've received online through one of the third-party donation sites. And each of those private donations, one by one, are qualified as being match eligible. At that point, it's essentially a formula for, let's say, for instance, a candidate is applying or taking $1,000 individual contribution, private contribution, and submitting that for public match. It's $2 for the 2 for 1 on the first $500, 1 for 1 on the second $500. So again, that once we get the request, I process it, it's submitted to Patty, who submits it then to the treasurer's office. And we have 5 business days to get the candidate their money. So again, getting it off my desk as quick as possible is paramount, because usually there are media buys behind these commitments. At the end of the day, or at the end of the election period, again, Dan McKee was eligible to receive $1,298,000. He received $1,295,511. Alan Gukian was eligible to receive $324,250. He received $181,469. Peter Nerone was also eligible to receive $324,250. He received $192,900. Both James and Diose and Greg Amori were eligible to receive $324,250, and they both maxed out at $324,250. So the total budgeted for matching funds this election period to the board was $2.7 million. The board paid out $2,318,380. The excess amount under budget goes back to the general treasury. For comparison, 2018, the state paid out a little over $1.8 million. 2014, a little over $2.6 million. In 2010, a little over $1.6 million. At the end of the election cycle, I do an audit of each of the campaign accounts and matching public funds accounts of these candidates, because the money can only be used for very specific purposes. Those purposes essentially have to do with purchase of radio or television time, rental space for outdoor signs or billboards, advertising space on a computer, internet, electronic device, and in newspapers, payment of the cost of producing the material aired or displayed on radio, TV, outdoor signs or billboards, computer, internet, and so forth, payment of the cost of printing and mailing campaign literature and brochures, purchase of signs, bumper stickers, campaign buttons, and other campaign paraphernalia, payment of the cost of legal and accounting expenses incurred in complying with public financing laws, payment of cost of telephone deposits, installations, payment of the cost of public opinion polls and surveys, and payment of rent, utilities, and associated expenses connected with the operation of elections headquarters or satellite election offices. I'm happy to say that for all 5 candidates, all the monies were expended for appropriate uses. There was no money spent for uses not allowed. Okay. After the audit is done, each candidate is required to refund back to the general treasurer 50% of the surplus of not just the matching the public funds, but 50% of the combined balances of their general operating account and the matching public funds account. So those monies have all been received and turned over to the general treasurer's office. In summary, Governor McKee turned back $4,584.37. Aaron Gukian turned back $4,026.72. Peter Nerone turned back $21,907.14. James Diosa turned back 0. He fully expended. He brought his campaign account down to 0 at the end of the period. And Greg Amari turned back $20,191.28. So this, I present this to you. If you approve it, it will go up on our website as a public document.
Thank you, Mr. Thornton. Any questions? Any of the board members?
I have a question.
Yes, Mr. Scholes.
Were there any candidates who did not qualify for matching funds?
Yes, of the 5 that did, that means 10 did not. And some of the reasons were, again, they weren't the nominee of the party. They were a party candidate that did not make it through the primary. So if you're a party candidate, you're only eligible to receive it if you're the nominee of the party. Others applied initially, but they didn't meet the qualifications of receiving enough in private contributions to qualify for the public funding.
So matching funds are only for the general election,
Yes,
not for the primary.
that's correct. Although I do understand there's a part of the omnibus bill. I think it will allow, even though it will be paid out after the primary, it will allow candidates to recoup some of the costs incurred during the primary.
One last question. I read the report, and to calculate the amount that's due afterwards, the 50%, that 50% is in the statute, or is it based upon the formula that you just talked about?
It is statute and regulation supports that. Yes.
Thank you.
Any other questions?
I just have one.
Mr. DeSimone?
Ray, I think Rick just said that we need to approve the report. I know the agenda indicates that we would just be receiving it.
Right.
Do you think there's a problem if we amend the agenda to approve the report? Or can we accept the report?
I think you can
and then-
accept the report. That might be the better approach.
I think so.
I'll move to accept.
I thought you did. Mr. DeSimone moves to accept the report. Do we have a second?
Second.
Seconded by Mr. Scholes. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed, unanimous vote of the board. Thank you. A lot of good work there. Thank you. Item number 7. The board may discuss and vote to commence a public comment period for a proposed regulation pertaining to the Independent Expenditures and Electioneering Communications Act, Rhode Island General Laws 1725.3-1, proposed by the Campaign Legal Center and Common Cause Rhode Island. I don't know if Rick or Mr. McCarthy, would you like to?
I can give a brief summary that motion pretty
Appreciate
much encapsulates the entire thing, but
Yes,
for those newer members of the board, you should know that the travel of this regulation to you today was long and arduous. This was originally submitted by the CLC, the Campaign Legal Center, and the Common Cause Rhode Island back in, I believe, 2018. And then shortly after that, there was a legal challenge to the underlying statute that was brought by the Gatsby Project, as well as a parent, what I would describe as a parent organization. That was filed in federal court. There were a number of constitutional challenges, including the claim that the people who are providing money, who are listed in the disclaimer, that's forced speech. To list your top 5 donors, for example, would be compelled speech and in violation of the First Amendment. And then there was a request for anonymity of donors because of the chilling effect that can have on the process of giving funds to subjects that may not be, or topics that may not be socially acceptable at the time. So that worked its way through the court system in federal court. The Attorney General represented us because there was a constitutional challenge. They represented us ably. Deputy Attorney General Michael Field, Special Assistant Kate Sedek did a phenomenal job both in the federal court as well as on the appeal to the U.S. Court of Appeals. And ultimately, there was a petition filed with the U.S. Supreme Court, which was declined. At that point, I believe CLC likewise filed an amicus brief. My recollection is that entire process brought us to the spring of last year. By the time the U.S. Supreme Court had finally ruled on the petition, and that returned it to us. Bob, Rick, and I have had discussions. We've had discussions with both John Marion of Common Cause as well as the able counsel of CLC to go through many issues here. There are a few changes since the time that I've raised questions and that we've raised questions. I think it's a well-written regulation, and it deserves the board's attention. It does follow the statute, and it would require a number of reporting. It gives the details needed for people who are going to be doing the reporting, as well as the disclaimers that are required under Chapter 25.3 of Title 17.
So Ray, when we first looked at this, you said it was back in, what'd you say, 2018, 2019?
My recollection is that there was a petition for rulemaking filed in the spring of 2018 or thereabouts.
And we actually did put this out for the 30-day period at that point? We did.
We started, and I think that counsel from CLC actually flew up here for comments and to
And that's
start
when
the
all of
process.
those appeals began.
That's when the
see.
first lawsuit was filed, yes.
Okay. And can you tell us what changes, you don't have to outline everything, but were there any significant changes to that since then?
No, this is, there were a number of detailed discussions, but we are satisfied with the answers we received from both Common Cause and CLC. CLC wrote this regulation by and large, and there are no major changes at all since they submitted it back then.
Okay. Any questions? Any other questions of our attorney?
I just have one question. CLC wrote, provided these input into the rules and regulation. Are there other states that have similar rules and regulations?
I don't know how pervasive this is. I think in some respects, including references to covered transfers, for example, that would be something that we're rather unique in, but I have not done a survey of other states. But I can say that the First Circuit decision is noteworthy. I mean, I think it once again and it clearly shows that the agency has a right to find out and to report and identify those people who are involved in these campaign activities, even though they're independent from the candidates and ballot questions themselves.
So that was a decision written by Judge Selya. Is that the one?
The First Circuit was, that's
Yeah,
right. I
okay.
remember we spoke about that when it came out.
Yeah. And he had certain remarks in there about the validity of the rules and regulation. Have all those been incorporated into this proposed change
From the,
from the
Court?
Circuit Court of Appeals?
no, the court affirmed the statute.
Okay, but they, I think they had some comments concerning some of the provisions.
To my knowledge, none that required a modification.
No, not a
And
modification, but I guess a validation
I see.
of the,
Okay.
of our proposed rules.
That
Yep.
is correct. That is correct.
Any other questions? Okay, hearing none, do we have a motion?
Move, that we put it out for public comment.
Moved by Mr. Scholes, do we have a second?
Second.
Seconded by Mr. West. Any discussion? Hearing none, all in favor, signify by saying aye.
Aye.
Opposed? Unanimous vote. Item number 8, the board may vote to convene an executive session pursuant to Rhode Island General Laws 42-46-5, subsection A24, and to discuss potential litigation and investigative proceedings. Do we have a motion to go into closed session?
So moved.
Moved by Mr. West,
Second.
seconded by Mr. DeSimone to go into executive session at 3:11 PM. All in favor?
Aye.
Unanimous. Do we have a motion to resume open session and to seal the minutes of the executive session at 3:32? Moved by Mr. West,
Second.
seconded by Mr. D. Simone. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, it's unanimous. We have nothing to report from our executive session, so at this time, we need a motion to adjourn this meeting.
Motion adjourned.
Moved by Mr. D. Simone and seconded by Mr. Scholl. All in favor?
Aye.
Aye.
We are officially adjourned. 3:33.
Thank you, everyone. Ray, don't leave. Okay.